On all things real estate today, we're focusing on the development and registration requirements for agents. I'm being joined by the Chief Operations Officer at the Real Estate Board, Cresfroid Brown. Did I get that right, Mr. Brown?
Correct, sir.
I'm correct. Just speaking to the mic a little bit so that your fans can hear you. Cresfroid Brown is correct.
You're correct.
There you go. Good. So here we are, the Real Estate Board, putting on this program once again, and its Chief Operations Officer is the man in studio. So then, everybody and their brother is a real estate agent these days, Cresfroid. So, who and what kind of, well, in terms of registration with the board, tell me about that process.
All right. Registration with the board involves completing an application form, paying the prescribed fee, if it is that you want to apply as a developer. So developers are those who are carrying out building, engineering works, which allows for some material change or use of the property. It can be that the property might be in an individual state, and you move it from, say, 1 unit to more than 5 units, or 1 lot to more than 5 lots. So those are the types of developments that we monitor, which includes residential developments, commercial developments, even those developments that are utilized for warehouse spacing. Once it exceeds 5 lots or 5 units, you have to register as a developer. Yeah.
Oh, you have to. So I thought that you had your money, you had your partners, and you just start build.
No.
No, I'm serious. I never knew that.
What happened, you know?
Yes.
The Act 1987, Real Estate Dealers and Developers Act, was promulgated, where it allows for some monitoring of these persons who are engaged in the business of development of land. So we are the government entity that monitors these persons who are engaged in such business. And at the same time, we offer protection to persons who are buying into these developments, whether for lease purposes or for sale purchase purposes. So once you pay down a development, we ensure that the monies which are utilized are used in a particular manner as prescribed under the Act.
Yeah. What you spoke to the application process, but what's the profile of someone who can apply? In other words, what does someone need to do, or what are the things that you need to have going for you to be able to matriculate to completing the process of registering as an agent?
All right. So you will need one. I noticed to use the word agent, so I just want to have a clear separation.
Yes.
So agents are those persons who are real estate salesmen.
Right.
So those who are developing is a
different group.
All right. So for developers, then you need to get the necessary fit and proper checks, which include a police report, bankruptcy checks. We also ask that you want to verify who's the owner of the property. So we ask for that the title be presented, a copy of the title. We also ask for the relevant approvals from the municipal corporations. So it can be either building and or subdivision, depending on the nature of the development that you're undertaking. If it requires an environmental permit or license from National Environmental Planning Agency, then we ask for those documentation and any other such agencies which are a part of the approval process. So we want to verify that these persons are fit and proper, one, and they have the necessary legal ownership or tied to the property to undertake such development, and the necessary approvals from the municipal corporation, because the Act works in tandem with other legislation.
Yes. Companion legislation. So what of someone who has, I don't want to say transgressed, but someone who has been registered as a developer then, and something happened and they've fallen out of favor, either with the real estate board or they found themselves in trouble with the law and they want to come back? What is the process for that person to return to a state that they were in as a developer and their status as a developer?
All right. As we know, with the law, due process has to be followed.
Yes.
So if someone would have breached the Act, then the board has the powers to can conduct a Section 9 inquiry into that person who is on the register of developers, or if in such case that person would have been convicted in the courts based on some breach in real estate or money matters, then the board would have to consider that application based on its merit and based on the matters levied against that particular person, make a determination. But due process has to be followed. You have to give the person a proper opportunity to be heard.
Yes. And of course, in these matters, given that they are at such a high level, you would expect that the person would have the right to representation and the right to a fair hearing for the issues to be ventilated.
Most definitely. Because bear in mind, we are in the business of fostering development, encouraging development, but we want to ensure that the parties who are involved are fit and proper, and above board, so to speak.
Yes. All right. So my producer says that there's something called a prepayment contract. What is a prepayment contract in the context of what we're talking about?
All right. So once you have a development and any party, whether it be individual, corporate body, wishes to pay down in that development prior to that development being complete, it constitutes a prepayment contract. So what it is that there are instances where the development is complete and a person will pay down. Those are not prepayment contracts. So it's only during the process of construction or prior to the works being completed for any development, if a party had paid any funds, those are considered prepayment contracts. And that those are in relation to any payment pertaining to any lot or unit within that development. So we always ensure that monies that are so paid are placed in a trust account. The term to be a trust account. In the banking world, they call it an escrow account. And that trust account should be development specific. So it allows for transparency in terms of monies coming in and how those funds are utilized within the project, which has to be verified by either QS prior to those funds can be removed.
Quantity survey or quality?
Quantity survey. Quantity survey.
There you go.
Or if you are paying
these things,
most definitely. Or it is that you are using those funds to pay for either stamp duty or transfer tax. So there should be some verification from the authorized financial institution prior to the releasing of those funds. So the developer does not necessarily go into their account and just withdraw the funds. They would have to submit necessary documentation to the authorized financial institution. That can be either a bank, building society, those under BOJ. To ensure that when those funds are to be withdrawn, that there's proper verification from the institution in alignment with the Real Estate Dealers and Developers Act.
Can the funds be held on to? In other words, is there something or a range of things that could happen whereby they say, well, this prepayment is now void by virtue of you having done these things?
Yes, void in the sense that, one, for example, suppose the person would have entered prepayment contract in breach of the act.
Well.
You understand? So the act allows for some sort of reprieve where the persons can be entitled back to their money and plus interest. If those funds have not been utilized. If it's a breach of the act.
Who makes a determination of the applicable interest?
At the commercial lending rate, of course.
There you go.
So section 26(2) of the act speaks to that kind of consideration. And there's another consideration where if in effect that monies are paid down and the development scheme should be filled, then we can step in and take over those funds. Of course, by court order. And exercise our mortgage over the property. Because normally when a developer uses the purchaser's fund, he's required to lodge a charge in favor of the board. So but bear in mind now, the funds placed in the development is utilized in the project. There must be some sort of protection to cover those funds. So we ask that the developer lodge a mortgage to protect the purchaser's fund. And that mortgage is only released upon the scheme being completed. And if the scheme is not completed and failed, then we take the necessary steps as a mortgagee to exercise our power of sale, so to speak.
Because the next thing I was going to go to, and you started answering that, I was asking about the prepayment contract and how it dovetails and how the attendant, I don't want to say regulations, but matters concerning the prepayment contract, how do those reconcile, if at all, with the purchaser's interests?
All right. Bear in mind, when you look at developments, it could be an instance where when the monies would have been paid, the monies are being utilized. Where the monies have been utilized, there is no claim of interest. But bear in mind, there is still an protection under the Act to recover the funds that you would have paid. All right? However, if the funds have not been utilized and it's within the account, then that's a different matter. Because it's within the account, the interest is being accrued, then whatever funds are in the account can be recovered in that particular case. But bear in mind, if the funds are being utilized in accordance with the Act, there's no claim to interest. However, steps can be taken by the purchaser through the courts, in the civil courts, along those lines. But based on our Principal Act, we can only recover the principal sums once the funds have been used.
And you said something I want to just to highlight, to underscore. The Real Estate Board, in those circumstances as you've mentioned, it doesn't just by itself act to hold on to funds or deal with issues concerning payments. It has to get an order from the court to execute, or it has the power under statute to just go in and do the recoveries or the straightening out that is necessary.
All right. If it is that a mortgage is not on the title, we have the powers to exercise power of sale under that mortgage. So we can take the necessary steps
without any court backing.
Because that is within the prescribed act. In order to take those necessary steps. If it is that the account is in the name of the developer and the account has failed, we can write to the bank to recover those funds. If there are any issues with the bank, then we can take the necessary steps through the courts to recover those funds under the act. Because bear in mind, those funds are being held in trust for the purchasers. Those funds does not belong to the developer until the developer fulfills the contractual obligation under the Act. So I would have say you paid down the money in a particular development, all right? There's an expectation that having completed the sale, you're supposed to get a particular unit or a particular lot. Having paid down the money, as a developer, if you fail to fulfill your obligation, and bear in mind now, these are steps. Based on the contract, you may pay, say, 10%, a further 30% at a particular date, and the balance upon the CPC being issued. Bear in mind, until you have fulfilled your contractual obligation as a developer, the purchaser is still entitled to those funds.
Yes.
And that's why the board comes in and protect the purchaser's money to ensure that at the end of the day, if I pay for a 2-bedroom unit, I get a 2-bedroom unit.
Yeah. I see. I hope you're following what I'm
Yes.
trying to get at, because here's the thing. Well, you are. The thing is this. I ask these questions because oftentimes you hear people when there's a dispute between themselves and their developer, a purchaser, them grumble and say, boy, the real estate board is not on the side of us, the purchaser. You know, the real estate board, like at the bank, them working with and coming down on the side of them. They're not really operating in our best interest. And those answers that you've given will defy all of that, because it is the purchaser that you are out there to protect, especially where funds that they have prepaid is concerned.
Yes, and bear in mind, it offers protection to the developer also.
But of course,
if once he complies with the Act, then there's some protection by law in terms of how he can use those funds. And in the event that the scheme does fail, there's some sort of reprieve to the purchaser, and probably some reprieve to him at the same time, him or her, in terms of whatever funds that they would have been contractually obligated.
Happy you said that, but that the
cover.
developer also has cover, But the reason I said it is because you really hear a developer ball and say, boy, the real estate board now work with them. But you hear people from time to time say, boy, so and so and so. When you examine the details of what their complaint is, you're saying, no, but the real estate board is acting as per statute. It's acting based on the powers that it has been vested with. So it is not that they're not taking your side. They're acting by law and going by how they are empowered to act under law. So there you go. Let me put this one to you. A friend of mine recently bought this property in the Russell Heights area. Not going to zero in on the local, and took delivery of the unit. Faucet not working, shower water settling, but the physical structure in the place mash up. To say that it's a brand new property for enough millions of dollars. And I'm saying, well, what is the protection afforded to people who make purchases like these from their developer, make purchases like these from developers, and when they take possession of the unit, it is at suboptimal standards? What is their recourse?
All right. So first, you have to start with what's in the contract. So we normally, not necessarily advise, but best practice principle, ask that the purchaser get legal representation prior to engaging in any contract with any developer.
Yes.
That contract should provide some sort of protection in the event that there is any defects. If there is a case that that unit has to be completed, that occupancy certificate that is normally issued by the professional, you should ensure that prior to you taking the occupancy certificate, that certain checks and balances are being done. So there's part responsibility of the purchaser to ensure that their interest is protected.
Yes.
Having gotten proper legal representation.
Yes.
Because bear in mind, if everything works in tandem, one would assume that the certificate that is normally issued should be valid in terms of the completed structure and the finishes as per contract or billing specifications.
Yes.
So if those work in tandem, then you shouldn't have an issue. But if there are defects, then there should be some reprieve based on the defects liability period under that contract.
Yes.
But you have to ensure that the proper representation is granted from the outset through an attorney to ensure that there's a form of coverage under the contract.
Last thing, we're out of time. We did a chat at the time ago. AML risk assessment survey. What do you want to say about it?
Very important, very important. We have international obligations.
Yes.
We ask that all licensed real estate dealer complete this assessment before February 14th.
How can they do it?
They're on our website, reb.gov.jm. There's a link to complete a risk assessment survey, and we ask that you comply. And it's in the nation's interest.
Yeah.
Because not only real estate dealers have to comply with these statutory obligations, but there's also other DNFIs or other persons, for example, lawyers,
accountants.
So it's an international obligation and as part of the national risk assessment.
And the deadline is Valentine's Day.
Most definitely.
All right. Cresfroid Brown, he's the Chief Operations Officer at the Real Estate Board. Thank you very much, sir.
All right,
good.